pass it back over.
All right. Good afternoon. My name is Patrick DeRay, and I want to welcome all of you to the Bureau of Automotive Repair public workshop regarding the extension of our citation program to various violations of the Automotive Repair Act. As Chief of the Bureau of Automotive Repair, I am glad that we have a number of our bar advisory group members, as well as some of the alternates to those members joining us today, coming back from a meeting that we held earlier this morning, our quarterly meeting of the bar advisory group. So welcome back to all of our advisory group members. And then we've also got a number of people, it looks like, sitting in attendance in the whatever the public viewing room is. We're now up to 25 additional attendees. So I think this is a topic that sounds like it'll get a lot of attention and interest from everyone. So I'm really excited you're all joining us again after a pretty lengthy meeting this morning. Hope you all had a really nice lunch and are ready to get started. I am as well. Any questions before we turn it over to our presenter? Okay, the workshop notice had a link to the presentation. If you don't have it, you can go to the workshop notice or just go to our website and pull up the regulatory workshop, and you'll have the presentation as well as the draft regulations before you, if you haven't seen those yet. But the notice itself should have the link easily accessible to get those documents. All right, let's begin. Matthew Gibson is with our Enforcement Operations Branch within the Bureau's Field Operations and Enforcement Division. That program handles centralized complaints, does all of the case management. What else? Oh, he can tell you of some of the other activities that they're engaged in over in the Enforcement Operations Branch. Work very closely with our Attorney General's office in the accusations, compiling all the enforcement statistics that are presented each quarter to our bar advisory group or to the department's annual report. Just a wealth of activity and responsibilities of that group. Matt has been with us for a number of years, starting out in field operations and now is working for the last few years with our Enforcement Operations Branch here in the Bureau's headquarters out in Rancho Cordova. So welcome, Matt. I will ask, I'm not going to introduce all of the bar advisory group members since this is not a bar advisory group meeting, but if you do have questions after the presentation, kindly introduce yourself. Please, to the extent possible, if you can turn on any video to make this as transparent of a meeting as possible. Just kind of want to simulate as best we can an in-person meeting experience where we can all see each other as well as hear each other. That will help make for a smoother meeting, I think, for everyone who's listening in or watching. So Matthew, or Matt as he is known to me, welcome, and let's have you begin with laying out what is in these draft regulations.
Well, thanks, Pat. And again, I'm Matthew Gibson. I'm a program manager in the Enforcement Operations Branch, and I'm here to discuss the proposed extension of BAR's citation program to Automotive Repair Act violations by registered automotive repair dealers. So as a member of an internal work group that looked into this issue, I presented on BAR's interest in creating an automotive repair dealer citation program and our rationale for doing so at the October 2020 BAG meeting. That PowerPoint presentation is posted on BAR's website, and that meeting is also on YouTube if you wanted to go back, because I don't know that I'm going to be covering, or I don't intend to go back into all the detail that we went into during that presentation. I should also say that even though the work group started looking into this issue in January of 2020, there is an assembly bill, which is 471 by Assemblymember Lowe, that if it does become law, would make changes to this proposed regulation, specifically as it relates to informal citation conferences, this informal citation conference process, and remedial training. And that was covered in part by Holly O'Connor this morning in the BAG meeting. The regulation text we are going over today is based upon the authority that currently exists in Business Professions Code section 125.9. So I put a PowerPoint presentation together, and it has 9 slides so that you can all follow along as I read the proposed text. So in addition to the PowerPoint, hopefully you have a copy of the proposed text, as it will make it easier for our subsequent discussion about the language. So can I get the next slide?
Oh, I apologize. I've given you presenter rights, so you can just hit the little arrows on the left-hand side and move the slides yourself.
Oh, well, thank you.
Yep.
All right, so this proposed regulation would give BAR the ability to create an automotive repair dealer citation program that is consistent with existing citation programs for smog check licensees and unlicensed activity, address violations of the Automotive Repair Act that do not rise to the level of an administrative action through the issuance of a citation, define gross negligence in automotive repair, and make other minor clarifying changes. So the first thing is that it's going to create a new article. So Article 11.1.2 would be citations and administrative fines for automotive repair dealers. It's going to create several new California Code of Regulations, the first one being 3394.30, which is the authority to issue citations and fines for ARDs. So 3394.30A says the director or his or her designee is authorized to determine when and against whom a citation will be issued, and to issue citations containing orders of abatement and fines for violations by licensees of the statutes and regulations referred to in Business and Professions Code section 125.9. 3394.30B says a citation shall be issued whenever any fine is issued. Each citation shall be in writing and shall describe with particularity the nature and facts of the violation, including a reference to the statute or regulation alleged to have been violated. The citation shall be served upon the individual personally or by certified mail. I have another new California Code of Regulations 3394.30, which is the citation fine amounts for ARDs. So the minimum and maximum fine amounts are established in Table 1, Citation Fine Schedule for ARDs. I will tell you that that table is actually what is slide 6 in my presentation. Will be to it in 2 additional slides. So a citation that lists multiple violations arising from an investigation inspection shall not exceed $5,000 pursuant to Business and Professions Code section 125.9. In assessing a fine, the Bureau shall consider the following: 1, the gravity of the violation; 2, good faith of the licensee; and 3, history of previous violations. 3394.31B, a citation may include a fine up to $5,000 if one or more of the following circumstances apply. 1, the cited person or establishment has received 2 or more prior citations for the same or similar violations. 2, the violation demonstrates a willful disregard of the law. 3, the violation could result in foreseeable injury or significant harm to the consumer's property or public. And 3394.31C, the citation issued under this section shall be separate from and in addition to other administrative, civil, or criminal remedies. So this is the citation fine schedule. It lists the violation sections and names we would issue citations for. It also records the minimum citation amounts and the maximum citation amounts. And so those would be, and by those I mean those violations would be false or misleading advertising, generating false or misleading invoice, conduct constituting gross negligence, disregard of accepted trade standards, failure to produce records for inspection, failure to possess required equipment specifically related to auto body repair, and payment of referral fees for towing delivery. And one other thing I'm going to say about this is that those violations, and I covered this in the presentation we did back in October, those citations would only be issued in situations where we were unable to demonstrate intent on the part of the licensee or the registrant. So a new CCNR 3394.30, I'm sorry, 32, contested citations and requests for formal citation hearings for ARDs. And this section would be the one that would be the most impacted by Assembly Bill 471. Because the way this is drafted, or it exists right now, it only allows for a formal citation appeal hearing. So anyway, 3394.32A, if a person cited pursuant to section 125.9 wishes to contest the citation, that person shall, within 30 days after service of the citation, file in writing a request for an administrative hearing to the Bureau. 3394.32B, if a hearing is not requested pursuant to this section, payment of any fine shall not constitute an admission of the violation charge. Hearing shall be held pursuant to Chapter 5 of Part 1 of Division 3 of Title 2 of the Government Code. And 3394.32C, failure of a licensee to pay a fine or comply with an order of abatement or both within 30 days of the date of assessment or order, unless the citation is being appealed, may result in disciplinary action being taken by the board, bureau, or commission. Where a citation is not contested and a fine is not paid, the full amount of the assessed fine shall be added to the fee for renewal of the license. A license shall not be renewed without payment of the renewal fee and fine. This the regulation would also add a new definition to California Code of Regulations 3303. And that would be 3303R, which would be gross negligence, which would be defined as a deviation from a standard of care that could foreseeably result in injury or significant harm to a consumer, personal property, or the public during or as a result of the repairs to a motor vehicle. Additionally, it would amend California Code of Regulations 3371, the title of 3371, from untrue or misleading statements or advertising to false or misleading statements or advertising. And actually, that was all the stuff that I was going to cover in my presentation.
All right, Matt, thank you very much. And thank you for pointing out the fact that Assembly Bill 471 by Assemblymember Lowe, who's chair of the Assembly Business and Professions Committee, would potentially alter these draft regulations if it were to be chaptered and signed into law. Let's take some questions and comments from, we'll start with Bar Advisory Group members, and then we'll obviously move to other attendees. I saw Dave Kusa, who represents the Automotive Service Councils of California. Dave, I'll let you, I'm sorry I stole your thunder from introducing yourself, but after telling everyone to do so. But let's have you kick us off with the first question.
Thanks, Pat. Matt, again, Dave Kusa, Automotive Service Council of California, and I am a shop owner in Campbell, California as well. Can you go back to the violation slide, the schedule?
Yeah, that one, right?
Yeah, perfect. Let me get this so I can read a little better. Sorry. There we go. So my concerns, currently under the leadership of Chief DeRay and a few previous bar chiefs, the industry, while bar does an excellent job of what they're tasked with doing to protect the consumer and the vehicle owning public, we enjoy a great relationship industry-wise with bar. So my understanding, my knowledge of history is that we make great moves here with these kinds of things under with the intention of fairness and which I have no doubt that's the case. Going forward, however, we may go back to some of those dark days when industry did not have a very good relationship with bar. It was a very contentious, if not banging of heads relationship, right? So some of these regulations could be overreaching if not implemented correctly. And then so specifically, what I would be looking at in here is disregard of accepted trade standards. I don't know what those are. There is not a list of trade standards. We don't have any document we can go to that describes specifically how any specific repair should be done or completed. We do have transmission regulations, some air conditioning regulations, So obviously smog, very limited brake regulations that were implemented some years back, but beyond that, there are no trade standards. So I have multiple questions. So who decides what a trade standard is, right? The false and misleading statements issue. Again, who just decides it's false and misleading, right? What may be false and misleading to a consumer, and I know you had mentioned intent, but it's pretty easy for a shop to use big words or acronyms that get lost in the translation, that may be considered false and misleading somewhere in the future. And then also the false and misleading invoice. Again, right, if no intent there, but which again you had said that it would be taken into consideration, but perhaps in the future that's not so generous. So a specific trade standard and or false or misleading statement that came to mind for me yesterday when I was looking at this is GM does have in some cases some very specific information on when to replace a brake rotor and when not to replace a brake rotor, and those were written for warranty purposes, so they wouldn't have to replace brake rotors under warranty, but it is a trade standard, right? The manufacturer of the vehicle says do this when this happens, don't do this if this is the case. As a general rule, many shops now replace brake rotors for a variety of reasons. So if we are doing a front brake repair, pads are worn, need to be replaced, we replace the brake rotors. On a GM car where there is a specific definition of when or when not to replace the rotor, but we replace them anyway with no real explanation, is that going to be violating a trade standard? And then, the other side of that would be, we're going to replace your brake rotors because of these reasons, right? We've learned that if we don't replace rotors, there's noises, brake pedal the brakes don't work as well, so on and so forth. Now, I know that from experience, but there's no documentation, right? I couldn't prove that in a court of law. So would that be a false and misleading statement? So those are, those are my concerns, I guess.
Okay. You want me to?
Please, I'm done.
All right. Well, do you want me to answer?
As best you can, sure. Yeah.
All right. So just let me take disregard of accepted trade standards. It's under Business Professions Code section 98847A7, right? But if you look at how this is drafted, the trade standards we're specifically referring to for issuance of a citation are the ones that are defined in the California Code of Regulations. So now we're not talking about brakes. As a matter of fact, there really isn't a brake standard in our regulations. We were talking about transmission, auto body repairs, ball joints, air conditioning. Those are the ones for which we have regulations. So your scenario wouldn't fall under accepted trade standards as far as if you replaced the rotors before what they theoretically went down to the minimum or the discard specs, right?
But GM has some very detailed, I'm just using that specifically as an example, but yeah.
That's fine.
But yes.
I would say though that in your situation regarding whether it would be a false or misleading statement, it would have to do with, that's just a bigger picture. Like, if you're not making an untrue or misleading statement in the process of selling a repair, then it wouldn't be a false or misleading statement. But if you say something that's untrue to sell something, then yes, then you would have a problem. The problem is, well, not really a problem. I say that where it falls on us is to determine if you're doing it intentionally, if you're doing it accidentally, and then it would depend on whether we felt you were doing it intentionally to sell stuff that wasn't needed, or if it was an oversight on your part. And then from there, we would make a decision about whether we would issue a citation under this regulation, or if it would be something we'd follow up with a formal action.
Okay. Good. That makes sense. I had one other question. Can a citation be issued without a fine?
Well, we do issue citations without fines in smog check.
Okay.
And we also for unlicensed activity. I don't see why they couldn't be issued without a fine amount. Having said that, I'm looking at minimum citation amounts of $100. So
that's why I asked you.
Like maybe we should be issuing these things I guess theoretically they could be issued for zero, but not the way that we have it drafted at the moment.
Cool. Thank you.
Let's go to our next hand that I saw raised. I'm just going to go down the list. Everyone will have an opportunity to speak. I'll just go down in order. Johan Gallo, Cal
Yes,
ABC.
Thank you, Pat. John Gallo, California Automotive Business Coalition. I want to kind of go back to conversations we've had with Chief DeRay when we were talking about cite and fine and all the work that's been done in previous years on dealing with disciplinary actions. And in our conversations, we were talking about looking at some of the more egregious and just out and out fraud type situations that he has dealt with, some of which have been showcased on news segments and things like that. And that when we're looking at cite and fine, those were the things that we were really trying to encapsulate in what we're trying to do with cite and fine. The concern that I have, and many of the members of Cal ABC have, as well as others we've had discussions with, Dave Coos has brought up a couple of them, especially when you're dealing with generating false and misleading invoices. If we go into just that one alone, having worked with the California New Car Dealers and the Automotive Advisory Services and doing dealership audits and seeing in some cases where the software that the manufacturer requires the dealerships to use truncate or have abbreviations in their system that they're not willing to change just for California. And that's just an example. But again, if we look at it and we have R&R or reman instead of remanufactured or remove and replace, that's a false and misleading statement. And I realize this is kind of being somewhat nitpicky, but I think it brings a good example of what we're talking about with at what point do we look at it being a false and misleading statement, which really constitutes fraud because you misrepresented the condition of the vehicle or the part or whatever the service would be, or you sold the work and you didn't perform it. And then if we look at gross negligence, again, if we're looking at a misdiagnosis, if we're looking at something that's a bona fide error where a person made a mistake, where does that kick in? And not to belabor it, I'll just hit one more and then I'll just make another comment and then go on from there. Disregard of accepted trade standards. I think you did a good job explaining the fact that we already have ball joint specs, we have transmission specs, we have the specs for minimal specs for brakes, and we have all the specs having to deal with auto body. But I think if we're going to have that on the grid, I think it behooves us to figure out how do we better define each one of these items. Because now there's a price affixed to it. Now there is a citation affixed to it. So I think we got to walk before we run. And I think we're kind of running into everything with this grid. If you go to your slide 7, this one really kind of jumped out at me from the standpoint that if a person is cited pursuant to 125.9, the concern is the person's never cited, even in the smog check program. We ran into issues with the labor commissioner and the Department of Labor Enforcement Standards that basically said, you can cite them all day long. You can make them be responsible for the business receiving a fine, but you cannot charge the employee that fine. The business ultimately pays for it. And so there's a concern there that regardless of what's on the previous grid, the $100 to $5,000, we've argued for a long time technicians should be registered because at least if they create the havoc in violation of the Automotive Repair Act, then they should be the one to pay the price. Because if they damage a business, all they have to do is push their toolbox onto the truck and they go down to the next business and do the same things. And so I think there's a concern overall that, let's not rush this thing and let's get it right. I mean, it only took us 12 years. Luana Polsky and I and several others were at the table for 12 years to come up with the disciplinary guidelines. And believe me, that was laborious, but we got it done. And I think it was a good product when we were done with it. I think, if nothing else, we should do this cautiously and make sure that we're really getting to the point of what Chief DeRay and many of us think, that when you have somebody out there that's intentionally breaking the law, that's intentionally harming consumers, we're right there with you. Take them out. We don't want them in the business any more than you do. But if they've made a mistake, a bona fide error, then let's make sure, to the earlier point that you made on AB 471, that we use the remedial training, that we use the interim step, that they go to additional training. Just like when a shop has a problem with bar, they have an office conference, they have a Right It Right class that employees would go through, kind of straighten up their act and then keep an eye and see if they're compliant. And I think what's in AB 471 will accomplish some of that. Lord knows we've spent an inordinate amount of time with Assemblymember Lowe's staff trying to really define what is fraud. And is a business really guilty before proven innocent, or are they innocent until proven guilty? And with that, I'm done with my comments. Thank you.
Okay. Can I ask one follow-up question?
Sure.
Just when we talked about this is disregard of accepted trade standards, you had mentioned that we wanted to more I think you said something about defining it more, and I'm trying to understand what you mean by that.
Well, right now, and if we go back in the history, and I think it's one of those that I think Chief DeRay and I and several other chiefs prior to him have talked about, the fact that many of the standards, like ball joints, would be a perfect example. They go all the way back to 1972, 73. If we're really going to implement coming up with reputable standards for making repair recommendations, when the auto body industry was having a lot of issues, they rolled up their sleeves and they went to work and they put together a lot of standards on what's acceptable and what's not acceptable. Just like right now, if we do diagnostics on electrical in a vehicle, most of us were taught when we were working on cars that you use a pick light and you trace it down. You do that on new wire harnesses, you may be buying that customer a whole new harness because you damaged it. So I think the whole point in that is, if we are going to come up with this regulation, what's the purpose if all it's going to cover is ball joints, brake jobs, transmissions, and what's in auto body? Let's take a look at the whole industry and figure out what are the standards. I think the point was made earlier about General Motors and certain guidelines they have on when you replace or don't replace a rotor. Under what standard? That would be their standard. Just like OEM recommendations, if you deviate from OEM recommendations, many shops are getting in trouble over that. And so I think we need to figure out, it's like the analogy I gave Marty Keller many years ago. The concern the industry has is BAR has been out there with a radar gun, giving, in essence, a ticket, which back then was a notice of violation, but there's no posted speed limit. Let's post the speed limit, let's have a standard, and then enforce to it.
Okay. Thank you for your comment.
Thanks, Johan. And also thank you for reminding everyone how we got here. Some interesting media attention with respect to how do consumers know when there's a shop out there that's committed violations, short of formal discipline to revoke the license or the registration of the automotive repair dealer. Maybe there's other violations that consumers should be aware of when they're in making a decision or in selecting a shop. And you pointed out how we used to have a notice of violation program 20 some odd years ago before it was eliminated following some very unfortunate misuse of that program by some attorneys who used it against shops and used it in quite honestly against the Bureau of Automotive Repair. It was a tool to educate shops, but it also was used to kind of file civil lawsuits against the industry for things that were more just educational in nature. And so nothing replaced those notices of violation when we disbanded with them some 20 plus years ago. And so nothing really exists between educating shops and formal discipline against the shops. So I think we're looking for some kind of middle ground to get some awareness out there, as well as another way of educating. Anyway, so I appreciate you kind of pointing that out. I skipped over that. Jack Maladona, California Auto Body Association.
Good afternoon. Thank you.
Hey, Jack.
Thank you, Matt. So I'm on page 6. That's probably a good page for my comments. Out of the 7 new, or at least proposed citations, I've got comments on 5. So let me take them one at a time, if that's okay. So the first one out of the box is false and misleading advertising citations. That one is broad, in my opinion, overly broad. You're covering BMP code sections 9884.7, A1, the CCNRs 3371, 3372.1, and 3373. It is very broad. First thing, I like to use an example here. So if someone there's an ad, or now with social media and websites, there may be an ad posted for for an oil change, for example. For an oil change, and they have the per 3372.1 at least half the type size. So what if it's not half the type size? It's 40% or less than half the type size. The concern here is that BAR representatives could be sitting at their offices looking at ads, and they may not even be executed by the consumer, and writing up citations for $5,000 for an ad that the type size is not at least half the type size of the listed price. So I think that's overly broad. That's number one concern. The second concern with false and misleading advertising is it implies intent. I mean, false and misleading advertising, I mentioned the example about the type size. That could be just a technical, non-substantive kind of problem. And now you're writing up a citation up to $5,000, calling someone a fraudster for really potential non-substantive mistake. So I think this has a lot of unintended consequences here. And so, I mean, technically it could be an inaccurate advertisement, but it's not false and misleading. There's no intent there. It could be, like I said, a mistake. And thirdly, the third concern is that, is this really necessary? In terms of, is this citation really necessary? Or is it an overkill? Consumer, in the hypothetical I gave, is not harmed in any way. If they execute the coupon and get the $29.95 oil change, I mean, who's harmed here? There's no harm to the consumer, and there's no fraud. But under that scenario, or that hypothetical, the BAR could write up a citation for $5,000 on a non-substantive minor type of issue. So I'm just raising the issue of, is this really necessary, or is this an overkill? Because you're really, the ad is part of the process of where if it's executed and there's fraud committed, that's what you're really going to, get the shop for. Unnecessary services or a bait and switch and that sort of thing. It's really the execution of the coupon, not necessarily the coupon or the advertisement itself. So anyway, that's the first concern, is with respect to the citations. I don't know if you have a comment on that, Matt.
Yeah, if we're going to go over 5 of these, maybe we should just go one at a time. Otherwise, I don't know if I'm going to remember the 3 parts of this after you get done with the 5th one. So let me just, we'll go here first. All right, so you brought up several different points. One of them had to do with the idea that, well, I would say that in the work group, I don't know that we were envisioning that we would have representatives sitting at their desks pulling, I don't know, ads to see if the font size was the right size in order to go issue citations. I don't believe that to be the intent. It's something that could or would theoretically be handled internally through a policy, but I'm guessing that based on what you're saying, you don't feel like that still leaves it too overly broad?
Yeah, I think there was in the past, let's face it, I mean, there was policy prior to this administration, or Pat DeRay's being chief, years past, where some of the BAR officials were told to write NOVs based on sitting behind their desk. So, I mean, there's some history to this. So obviously there's a concern about that particular issue. I know that's not the intent, but it doesn't prohibit, there's nothing that's prohibiting a BR representative from sitting behind their desk and writing up violations for $5,000 on advertising, right?
Okay, I will say just quick things that I have another follow-up question just about this specific point, but I would say the way that this would work would be no different than it would work for our smog check citations or our unlicensed activity citations. The citations the reports would be generated in the field, and then they would be sent up to, well, EOB, where I work, but the review staff here, and we would actually be issuing citations if we felt that the field had enough evidence to warrant issuance of a citation based on the evidence that they provided. So that's why I asked about the policy, because like if we had an internal policy that said, hey, we're looking for situations that are real world where we have somebody who actually had an advertisement, right? And they went into a shop and they asked for the advertised price, but didn't get what they should have gotten as identified through a consumer complaint investigation. That would be the scenario where we would probably want to issue a citation with this regulation versus somebody sitting at their desk, pulling the penny saver, trying to find font size issues and issuing citations for false and misleading advertising. But if I take your point, it's a good comment. What we do internally as far as our policies can shift over time. Do you have an idea how to address that?
Well, I think you need to change the underlying regulation that talks about false and misleading, because in the scenario, it may be an inaccurate advertisement, but it's not false or misleading. And I think, I just don't think that really, it's not the ad itself, it's what I call the execution of the ad. You know what I'm saying? That's what really you're after, right? And so I just think this is an overkill. I don't think this is a necessary citation, frankly. I mean, if someone's going to, execute the ad, you're really going to go after them for the oversell and all that kind of stuff. That's what you really want, right? You're not going to even issue a citation for that. You're going to go after them for a disciplinary action or run undercover cars on them.
That's exactly right. If we felt we had an intentional act, if they were intentionally deceiving the public through their advertising in order to sell services at a price or sell things that were not necessary, it wouldn't be a citation. It would be us initiating an investigation to take disciplinary action. And so, you know what, if you posed the term inaccurate, so I think that we want to make sure that the regulations or the citations that we've issued under this regulation can make it so the consumer can understand what it was that we found. The 3371, 3373, well, I guess 3371 says untrue or misleading right now, which we're trying to change. But if we, that being the title of those sections, you're thinking that if it had something other than false or misleading, something like inaccurate, you believe that would be still conveying what we're trying to say without identifying somebody as committing a fraudulent act? Is that what you're saying?
Well, it helps, but I guess what I'm saying is, I don't even know if you guys really need this citation, but
Okay.
I just don't think you need it, frankly. Let me jump to the second one, which is generating the false or misleading invoices. Same kind of issue here. Again, it implies intent, and you may not have intent. That's why you're doing the citation, right? I mean, that it may be an inaccurate record of some kind, but calling it a false or misleading invoice, I think, is misleading the consumer. You're calling them a fraudster when, let me give you an example, because I think examples really make the point here. So maybe, I don't know, in transmissions, and I'm not a tech, but you have solenoids. Maybe, the shop bought 4 solenoids and comes in a packet. In any event, they listed 4 solenoids on the invoice, but they actually installed 3 because that's what the vehicle took, okay? And they had an extra solenoid and they just discarded it. But the point is that the invoice itself said 4, solenoids, 4 items, but they actually installed 3. And in that case, I'm just saying, hey, that's just, maybe the invoice is inaccurate, but you're going to call them, it's implying you're going to issue a citation for false or misleading. I don't think that's appropriate. I think it's mislabeling, what occurred here. So I have a concern about the labeling issue with respect to the second item about invoices, and I think that may need to be changed, Matt. I think more technically, it's an inaccurate record, an inaccurate invoice, or something to that extent. I mean, I think it needs to be relabeled, and you may need to change the actual underlying regulation 3373.
Let me jump in here, if I may, Jack. I appreciate the comments you've raised with respect to both of these and the comments to come. But I just want to lay out how we got to some of these violation terms or names. This comes straight from the Business and Professions Code. Specifically, you can see in the violation section column, BPC, that's Business and Professions Code 9884.7. So we tried to use that as the framework of the model for the terms that are used in the Automotive Repair Act for violations of the Automotive Repair Act. So yeah, I understand your point about the language not necessarily being representative of intent, and maybe there's some wordsmithing or finessing of the language to kind of downplay that an act that's more deserving of a citation that doesn't connotate with a intentional act of fraud, and we can look to work on that. Again, the work group that was tasked to come up with these citation parameters or this citation language, they were just going back to the Automotive Repair Act and the way these violations are described in the Business and Professions Code. So yeah, we can look at modifying the violation name different than the Business Professions Code lays out, to kind of get at your point of these aren't intentional acts, these are more mistakes, I guess, if you will, on the part of the shop that's violated these sections.
Pat, so what's really important here is the labeling is very important, because if you're going to describe something as false or misleading, Matt talked about AB 471. That wouldn't be eligible for the remedial training, but if it's an inaccurate record, it would be eligible for remedial training. So those labels are very important, and especially if you can't prove intent. And I think that's one of the reasons why I think, Matt, you've indicated here you'd issue a citation, because if you can show intent, you're not going to issue a citation. You're going to go after them for a disciplinary action, right? Attorney General action. So I think you need to label things accurately, and I don't think the labels on those two are accurate.
Okay.
Okay. Let me go to the definition of gross negligence, and I have to say, when I read it, because I thought the way you define it means a deviation from a standard of care, and I have to tell you the way the definition reads. It reads as just negligence. I mean, and so gross negligence. When you look at the cases in this, means a deviation. I mean, it's a extreme departure. It's not just a deviation; it's an extreme departure. And I think the definition is inaccurate. And so, I mean, you can't, the regulation can't trump the statute, because the statute talks about gross negligence, and the definition, to me, it's like negligence. So I don't even know if this would even get passed by the Office of Administrative Law. So I think you need to relook at this definition, Matt. I don't think it defines gross negligence.
Okay, and so in our minds, what we're trying to do through how this has been defined, and I'll follow up in a second, I'll just explain though, it has to do with the safety issue that it has come as a result of somebody. So the car is now unsafe, right? It's unsafe for the people in it, or it's unsafe for the people around it as a result of the shop having worked on it. We don't really have negligence. We have accepted trade standards, and then we have gross negligence. Like, those are the two deviations of care, like, standards that we have. And I bring that up because if we talk about accepted trade standard violations, which we're covering through a citation anyway, we'd be talking like somebody who didn't, I don't know, whatever is within our accepted trade standard regulations, like they didn't replace one of the gaskets on an automatic transmission rebuild or something. But if it's grossly negligent, they have actually caused the vehicle to become unsafe. I think if everybody's in agreement that if you make a car unsafe for the people in and around it, that's grossly negligent conduct. I mean, do you have a suggestion on how or what we could insert, or what do you think we can do to make this more what you have in mind as far as grossly negligent? Because I think if somebody actually created a vehicle to become unsafe and people weren't like actually hurt, like they were only hurt a little bit but not a lot, like that would just be accepted trade standards versus violation. I guess that's what I'm trying to get at.
Well, I mean, you can change gross negligence to mean extreme deviation. I mean, that it's just not just a deviation. It's more than that. That's what gross negligence. Because otherwise, you're defining negligence. That's my problem.
Okay.
So I mean, that's what I would. It would be extreme. I'm just throwing an idea out. I'd have to look at it carefully, but the definition that I'm seeing there is basically negligence.
Okay.
So, okay, that's just a comment. I wanted you to, take a look at that and review it. And I could send you some cases that define gross negligence, if that's helpful as well. Let me jump to the next one. Page 6, going back to page 6 again on the screen. So the other violation is for failure to produce records for inspection. Okay, and I think on that one, there are a couple things I want to raise. Number one, I know from past experience that sometimes the representative, a BR representative, may ask for 60 days worth of records from a shop. And you got some shops that are doing a lot of volume. I mean, they may have 100 cars and they may have thousands of documents. And it would be unfair for them to, I think, issue a citation for if the shop says, I'm not going to produce 60 days worth of records. I don't think that's fair. Now, with regard to the specific complaint, the consumer making the complaint, I can understand that. Those documents, that's an individual complaint, those documents from that one consumer. So I don't know, that needs to be addressed somehow. It needs to be more specific. And secondly, the other issue with regard to producing records, because I know some shops don't want to produce records, not from the consumer, but I mentioned the 60 days, because they're concerned about privacy issues. Shops are entrusted, and there are laws that don't allow them, or at least to protect the consumer's privacy. And so by potentially producing records that they're not related to the consumer, because the consumer, I think when they make the complaint, there's an argument that they may have waived some privacy issues, but now asking for these additional records, 60 days worth of records, for example, I think there's some, I think the shop can say, hey, I don't want to produce them. There could be some privacy issues here. And you need to take those in consideration. So I think on this one, this has got to be really narrowed down to just, listen, if the shop doesn't produce the complaint, from the consumer, that's one thing, but to have it really broad where it could apply to additional records from other consumers that didn't even file a complaint, I think that's a problem. So this needs to be really narrowed down quite a bit, Matt.
I would say that your observations related to, well, let me just say this again. It would follow, that citation would theoretically, well, if it existed, it would follow the same process as I described related to false misleading advertising. What I hear you saying is that you feel like it's overly broad. You use the same statements, obviously, for false misleading advertising. Are you thinking that, I guess I'm trying to say, you feel like it's overly broad. Do you feel like there's a way that, I'm trying to understand how to make your comment, like how to work that into understanding how to adjust the regulation. Like, is there something that we can do that, what are you trying to say?
Well, it'd have to be specific to one complaint. I mean, to the consumer's complaint and their file, in other words, right? You have to narrow the language down to where if you don't turn over the consumer made the complaint in that particular, those records, you know, you can issue a citation. But if the rep asks for the records for the consumer that made the complaint, that's one thing. But if they ask for records for 60 days and then I don't think they can they shouldn't be able to issue a complaint or a citation for records for 60 days of consumer records. That's my point.
I'm going to jump in here and just ask a question. How do you know that it's not related to a complaint? Maybe we've gotten 2 complaints. Maybe it's just, maybe it's 2 complaints. Maybe it's a couple, 2, 3, 4. And we are asking for additional records that are trying to determine whether there's a pattern going on. How do you get there unless you're just waiting for the 5th complaint to come in? I don't know when I'm not saying I disagree with what you're saying. I just don't know. How do you know it's not related to the complaint? It could be related to that initial complaint, and you're trying to find out if there's more there than just has happened by circumstance, by just that consumer happening to hear about the Bureau of Automotive Repair and knowing that this agency exists and decides to file a complaint. What about all the other potential consumers who haven't filed a complaint because they didn't know there was such an agency out there? And there is maybe a connection to that complaint, the one that you did receive, and the many others that you may not have received. So I'm just raising, I guess, maybe food for thought, or just some, for the sake of argument, that you don't know that it's not related to the one complaint that you did get. So I'm not saying whether we should have a citation that goes beyond that program that for failure to produce records beyond the complaint. I'm just saying you don't know.
Well, I guess my point is it's got to be narrowed down and very specific to a consumer complaint, a specific consumer complaint, and it doesn't need to be broad. I think I guess I have concerns that this could be potentially abused, so I want to make sure the language is drafted in such a way that it's clear to the shop and to the to the BR rep. You're asking for specific records for a specific complaint, and not 60 days worth of records. That was my point.
Yeah, it could be. I agree with you. It could be abused by bar, but it could also be abused by industry if we ask for records beyond that consumer complaint to try and see if there's a pattern of behavior here that's unacceptable. They could say, well, no. And what's the recourse then? I don't know. But disciplinary action to revoke the license, I don't think anyone wants to go there.
Okay. I just wanted to make those comments. Also, going back to the 5th thing, the 5th area was disregard of accepted trade standards. And I know that specifically you're trying to capture CC&Rs 3360 to 3367, which includes ball joints and air conditioning, transmission, and some others. The only comment I have there is that some of these standards, frankly, are potentially outdated. I mean, I've been hearing some issues, and some of those things. The technology in these vehicles have changed quite a bit, and I think that before we start issuing citations on these trade standards, that maybe the underlying trade standards need to be updated. So that should be considered as well.
Okay. Thank you.
And then the 2 final comments I'll leave you with is with regard to the minimum citation. Is there any reason why, I don't know, where did the $100 come from? Why can't it be 0 as the statute calls for that? 125.9 C1 says that you don't have to have an amount. So it could be from 0 to 5,000. I understand the 5,000, but I don't know why that 100 came about.
I believe it had to do with consistency with the Smart Check citation program, but I understand what you're saying.
Yeah, I just want to make sure we're clear, right? The statute says you don't, it could be 0, right?
Could be 0.
Yeah, okay. I guess my recommendation would be it should be 0. It shouldn't be 100 to 0. I mean, it gives you discretion. I mean, they can issue the citation for 100 or 50 or 0, but I mean, when you list the minimum of 100, I guess the BR representative feels like if they're going to issue a citation, it has to be 100. So I think if it's 0, which the statute does call for, I think I would recommend it's 0. And then my final comments have to do with factors of mitigation on page 4.
On slide 4?
Yeah. So in assessing the fine, it says here that, yeah, you have 3 areas. And I'm not sure why, when I saw that, I thought, you know what? We spent a lot of time on the factors of mitigation in the disciplinary regulations where there's some additional things the Bureau should consider. For example, evidence that the respondent implemented the BR suggested a resolution to a consumer complaint, evidence that the restitution to consumer and the repairs were made to the consumer's vehicle. You see where I'm going with this? Absence of any prior disciplinary action. So there's some additional items that could be included in there. In other words, for the BAR to consider. I just want to bring that to your attention too. That may be something that could be referenced or included in the actual text of the language.
I think we can take a look at that. Those 3 come strictly from Business and Professions Code section 125.9, if I'm not mistaken.
They do, but it says it's the minimum. That's the minimums.
Yeah.
Yeah.
There's no reason why we couldn't add to it, right? I mean, that's okay.
Absolutely.
Okay. All right. Well, those were my comments. Thank you very much.
Thank you, Jack. Let's go to Lou Anapolsky, who's been patiently waiting his turn. Lou, how are you? Good to see you.
Hi, Pat. How are you?
Yeah.
Good. Hi, Matt. How are you doing?
All right. How are you?
Good. So a couple observations when I read over the materials in preparation for the meeting today. First, I think when any bureau, board, or agency undertakes the arduous task of trying to regulate a particular industry, one of the things that the agency has to, or the bureau has to be concerned about is credibility. And credibility here is going to depend, I think, in part on consistency. Consistency in how this scheme, if it's going to be adopted, how it's going to be implemented. For example, I think what we can see from the comments that we've heard so far from John and from Jack and Dave, the devil is really in the details here. It really is. And so it may sound like we're nitpicking, but we're not nitpicking, not at all. So let's talk about how this program, if it goes into effect, how it's going to work. First of all, one of the things I noticed is there isn't any criteria as to when a bar field rep is going to issue a citation versus something else, like an informal office conference. When are we going to go to an informal office conference? When are we going to use the citation? Can a citation be issued at the end of an informal office conference? Probably. If that's the case, then you've just basically defeated the purpose of an informal office conference, because if a licensee knows that they could be cited at the end of the conference, Matt, I think your communication is going to be stilted. You're not going to get a free flow, a good dialogue between the bar rep and the licensee if the licensee knows that if he or she says something out of school, that's going to result in a citation. And what we're trying to do in the informal office conference is educate, in part, educate and bring the licensee into compliance with the law. ask the question, does the citation, cite and fine program that you're proposing, does it basically achieve the purpose of this informal office conference? Is it educational in nature, or is it more punitive? That's the first thing. That's the first thing. So I'm curious as to how the bar field representatives are going to know around the state as to when they're going to be issuing citations as opposed to lesser forms of, for lack of a better term, discipline, lesser forms of trying to bring the licensee into compliance, like informal office conferences. Now, going down and looking at the some of the issues here, Jack is 100% correct in terms of gross negligence. That is not the legal definition of gross negligence, not even close. So the California Supreme Court defines gross negligence as a want of even scant care or an extreme departure from the ordinary standard of conduct. And you're going to see that language repeat itself both in federal court cases, in the Ninth Circuit Court of Appeal, and you're going to see that throughout California appellate courts and our California Supreme Court. As opposed to negligence. What's negligence? It's a failure to exercise the degree of care in any given situation that a reasonable person under similar circumstances would employ to protect others from harm. Your definition here of gross negligence comports with ordinary negligence. It does not comport with gross negligence. If you were to successfully prosecute somebody or even issue a citation under gross negligence, and that was taken up through the Court of Appeal, my guess is that you would lose that case because that's not the law. That's not the law. So what I guess my big concern here is, how are we going to consistently implement a cite and fine program throughout all of the field offices and all of the bar field representatives in California? Are you going to issue guidelines to help them as to when they know they should issue a citation versus some other form of bringing the licensee into compliance?
And I would imagine that would be exactly the case, as whenever we rolled out a new citation program, like when we did unlicensed activity, for example.
Okay, so now one of the things that I wanted to bring to your attention, and Matt and Pat, is that we're talking about 9884.7 of the Business and Professions Code. That's the Automotive Repair Act. 9884.7 has 9884.7A5, you can be disciplined for engaging in conduct that constitutes gross negligence. Okay? Nowhere in 9884.7 do you have a provision that allows the bar to discipline a licensee for ordinary negligence. Doesn't exist. Okay, then you say, well, there may be reasons for that. But that is not determinative in terms of should it be there. I think, Pat, you know that I've practiced administrative law for over 40 years, and I've tried cases in front of many different bureaus and boards. Let's take the medical board, for example. And I've tried many different cases in front of the medical board. The medical board version of 9884.7 is 2234 of the Business and Professions Code. There, it talks about unprofessional conduct. And you certainly do find gross negligence. If a doctor commits gross negligence, that's unprofessional conduct for which the doctor's license can be disciplined. But we also have different sections that follow gross negligence that speak to things like repeated negligent acts, an initial negligent diagnosis, and so on and so forth. And that's just one board that has a licensing scheme or program where we have gross negligence and negligence both mentioned as separate grounds for discipline. The closest that you have for 9884.7 for automotive repair is a willful departure from or disregard of accepted trade standards for good and like repair in a material respect, etc. That's about the, but that's not really a definition of even simpleness. So I think we've got, when we talk about gross negligence, and you're going to try to define gross negligence with a simple negligence definition, it's not going to stand the scrutiny of judicial review. And the appellate court is not going to allow that to stand. So I think Jack is 100% right. That language needs to be changed. It needs to you need to understand what gross negligence is within the meaning of the Automotive Repair Act. And again, I've litigated gross negligence cases. And this is not, if I had to litigate gross negligence based on this definition, there would be very few licensees in California that would be able to survive something like that. Okay. Pat, that's about all I have.
Thank you, Lou. Excellent points. Yeah. All right. Let's keep continuing down the list. Joanna Johnson, Automotive Oil Change Association.
Hello there. Hi, Pat. Hi, Matt. I want to ditto everything Lewis and Jack just said about gross negligence. They've said it perfectly, so I don't need to reiterate, but that's very important. And because whatever it is we're going to do here, I presumably want it to stand up. So that would be great if we could work on that. And if you need people to work on that, raise my hand. Here's a question I have back to accepted trade standards. Wondering if you thought through whether or not you would possibly be applying that to preventative maintenance situations. I know that that's not a natural fit, but you now have quite a few ARDs who are strictly preventative maintenance people. And the thing that came to mind for me of concern is that it's pretty common for the OEMs to put down service intervals that highlight the longest possible interval and are usually for a style of driving and conditions of driving that rarely exist. And when you're out in the field, you have to look at the actual condition of the car. You have to look at how the people want to drive their cars. And, you know, whether or not they've been in fires or floods or all those different kinds of things when when they are actually deciding how often they're going to have their services done. So that's why the question comes in. When I saw this list, I thought, I wonder how that's going to work out when an inspector comes to a preventative maintenance shop.
I would just say that no, it's not included. It's not one of the CCNRs that are under the accepted trade standards. So preventative maintenance at the moment, as is drafted, wouldn't be something we'd be issuing a citation for.
Would not be in there at all. And is that something that might be noted anywhere in the regs or in documents, you know, in regulatory documents about the regs before it's published? Any discussion or regulatory history?
As far as that, we aren't intending to include maintenance schedules.
I think Joanna's asking any statement that would spell out that list of trade standards in our regulations. And yes, that's the initial statement of reasons that would accompany the regulatory package, the package the document that justifies the regulation. So it would point to our accepted trade standards that are in our regulations in those half dozen or so areas.
Okay, excellent. Thank you very much.
Thank you.
Our next hand raised, thank you, Joanna. Next hand raised, Bud Rice, also with California Automotive Business Coalition and Quality.
Good afternoon. Good afternoon, everybody. First off, my apologies. I tried to do my video so that my face was blurred out and the background was crispy, you know, but I did it backwards, so you have to look at my face. So I apologize for that. I wanted to make a fast comment on page 6 that you're on right now. And I'm saying this with a little bit of a smile on my face, but I'm really not. If you look at those top 3 things that are on page 6 there, I could see something happening where somebody comes in and goes, well, you're that false and misleading advertising guy. And all of a sudden you get tied into the second one at the same visit, and now you got the daily double going because of the false and misleading advertising, you've also generated a invoice that is propagated from that first one, and then you're going to go for the trifecta because now you've also maybe committed gross negligence, and you got all 3 things going at the same time, and in the blink of an eye that poor guy's down 15 grand. So I don't know where things break and where you go, well, when we have to do one of these things, it's a one shot deal here. But I could see combos going here that would really be dangerous. So I just kind of wanted to bring that up. Thank you.
All right, thank you for the comment. I don't know if there's a way to say for multiple violations that it's no more than a certain dollar amount. That's something for us to take a look at. Let's see. Hands raised. We can go back to Johan Gallo with Cal ABC.
Thanks, Pat. Just a quick comment. I know we've been talking a lot about gross negligence. And when we really get into what we're talking about here, we're talking about workmanship. When you really think about it, was it poor workmanship? Was it a job that wasn't repaired to what even ASE would use as a repair standard for what's required to do a brake job? So to Lou and Jack's point and everybody else's, when it talks to gross negligence, why aren't we talking about workmanship and workmanship standards? Because to Lou's point, if we're going to stick with gross negligence and we're not even going to follow the Supreme Court standard on ruling on gross negligence, then what are we really talking about? So I think we need to reconsider what we're looking at when it comes to workmanship.
Okay.
That's my only comment. Thank you.
Appreciate that, John. I don't see any more raised hands from the advisory group members, but we can circle back. I want to now move to some of the other attendees who aren't necessarily bar advisory group members. Moderator, you have some hands raised. You can also ask for comments from those who might not have figured out how to raise the hand feature. We have a Jonathan Summers, and I let's see, I don't know if there's others. If you could help me there.
It looks like I only see a hand raised from Jonathan Summers. So
Okay.
Jonathan, I'm going to unmute your microphone now.
Good afternoon, Pat, Mr. Gibson. A couple of comments listening and going over this. First off, will there be any remedial training along with the citation?
So not as it's currently drafted. What you're referring to is actually something that's included in an assembly bill that may or may not become law.
Okay, the second question is just to follow up on a comment that Mr. Gallo made. We're given a citation for a speed limit when the technician doesn't know the speed limit, or the driver. With the Right It Right course that's so well written and that address a lot of the invoicing issues, had that ever been considered as a almost as a mandatory training?
Well, I would just say the Bureau does offer the Education First program for all registrants that become like new ARDs. We do have an option for them to allow us to come out and go over the Right booklet with them so they can get educated on the laws and regulations related to estimates and invoicing. Having said that, the code sections we're talking about aren't about authorization necessarily. They're not about, not having your ARD number on an invoice. It has to do with untrue misleading records or untrue misleading advertising. So I don't know. If you're saying, should we require all, are you asking, do you think we should, I guess it's a question more for you. Do you think everybody should have to go through a write presentation?
Oh, absolutely. If there's going to be citations involved, absolutely.
Well, I think that's a very timely and comment, because AB 471 seems to envision that laws and regulations training would be incorporated into a citation program if we go down this road. And so I think that's really a very prescient comment on your part, Mr. Summers. So yeah, we'll have to take a look at incorporating a laws and regulations program into and certifying training providers who perform this as called out for in this pending legislation, AB 471 by Mr. Evan Lowe. Take a look at it if you haven't seen it. I know many of the Bar Advisory Group members are familiar with it, but for anyone else out there who hadn't heard about the bill, take a look at it, because it ties into the citation program that we're talking about today, the proposal, I should say.
Absolutely. As the owner of California Smog and Automotive Institute for the last 17 years, it amazes me when I teach the Right program to ARD that are seeking their smog certification. They're surprised that information is out there. So that's the reason I wanted to bring that up. The second comment I have is on the false and misleading advertising. How does that apply to non-ARD vendors? Example, AAA does our advertising, Repair Pal does advertising, Auto Shop Solutions does advertising for the ARDs. And some of their advertising can lead to the false and misleading from the consumer's point of view. Anybody want to address that?
Well, let me just ask the question to answer that question. Follow up your question with a question. Are you required to accept those third-party advertisers' coupons or advertisements when they bring it into your shop?
As a AAA service provider, absolutely, and as a Repair Pal repair shop, absolutely.
The only thing I would say is that given what we're talking about, it's an advertisement that reflects something that the consumer is entitled to, is that if they do not get for the advertisement, you'd be in violation of that section.
Got it. Even though the repair shop has nothing to do with writing that advertisement.
At the point that you accept the advertisement, it's yours.
Okay. Third comment. The referral fee to the towing provider. Isn't that a fee that should go both ways?
Actually, it is. In that section 3368, it does talk about a reimbursement or a referral fee from, it goes to the shop to the tow company or the towing company to the shop.
My apology, I'm referring to the citation.
On the citation, it refers to a CC&R 3368. Oh, I can't see my PowerPoint.
So both the tow provider as well as the shop can receive up to a $5,000 fine.
Well, I can't issue a citation to a tow provider because they're not registered with us.
Right.
But I can issue one to a shop that is registered.
Gotcha. So no repercussions to the tow provider that says, hey, shop around the corner gives me $50 a tow. What are you guys going to do? And you say, no, I don't want to risk the chance. Now I just lose of course, more than $5,000 in tow bills.
Towing operators are not regulated by the Bureau of Automotive Repair.
Okay. And my last comment, with reference to the gross negligence, the disregard of accepted practices, the false and misleading statements. What about your part stores that do the code reading and and don't follow acceptable trade practices?
So the accepted trade standards that we were referencing are the ones that are in the California Code of Regulations, and so related to the work that those registrants are doing, and some of those places actually are registered with us. I don't know that they're doing the work that falls within those trade standards. If they were, then we would issue them a citation if they violated that trade standard.
So you're saying that everything that's on slide 6 applies to those auto repair stores, auto parts stores as well?
If they're registered with us, yes.
Okay. Thank you.
I guess I should say related to automotive repair. Yes.
Okay, thank you.
All right. Moderator, are there any other comments coming in from the attendees?
It does look like we have two more requests. I have one from Stephen Etheridge. Stephen, I'm going to unmute your microphone now. And Stephen, you are unmuted.
There, I've unmuted my end too. Better?
Yep, we can hear you. Thank you.
Excellent, thank you. Basically, I just sent a explanation of gross negligence from the Judicial Council, CEACI number 425, and if you want to look at that link, if there were any legal definition related to gross negligence, this would cover it. And I think it'll add some clarity to what's going on. Basically, if you put anybody else or yourself in danger by your behaviors that a reasonable person would not be involved in, whether it be working on a car or driving incorrectly or just not taking into consideration what might happen if, you can be guilty of this by either omission or intention. So there's a number of formative questions.
Yeah, Mr.
There's a number of formative questions.
Where is that information that you are?
I just gave you a link.
Oh, okay. If you could send it to us. Good. Thank you.
I hope it's helpful.
Appreciate it.
Hello, this is David calling back
And
on the program.
I'm having a trouble with the definition being split between gross and regular negligence.
It sounds like
minor negligence.
Yeah, it sounds like that's a common theme, and obviously we fell short of the gross negligence definition in our first attempt at this. So that's why we hold these workshops, to get this feedback.
I understand.
We have someone who's got some background.
A little bit of sand in my peanut butter, or a lot of sand in my peanut butter doesn't make any difference to me.
Good analogy. All right. Any other comments, Mr. Etheridge?
No, sir. Thank you very much for allowing me in. I appreciate it.
Yeah, if you send the link to our moderator, she can make sure that she passes it on to us.
Very good.
Thank you.
All right, and we do have another request for comment from individual identified as Rocky. Rocky, I'll be unmuting your microphone now.
Thank you. Can you guys hear me?
Yes.
Great. Hello, Mr. DeRay and everybody else. Thank you for all you guys do. Appreciate everything. I'm trying to make it as simple as possible. How is it that a government agency can fine someone when there's no standards provided? It's very difficult to ask someone to behave certain way when you don't tell them how to behave that way. And I'm not talking normal behavior. I'm talking as standards of automotive repair. if the automotive repair had certain standards and those standards were not met, I wouldn't have a problem with the fine. Otherwise, this is like you could be fishing for fine forever. Thank you very much. I really appreciate it. Thank you for the time.
Thank you.
Thank you, Rocky. Good to hear your voice. I gave you a plug earlier today at our bar advisory group meeting. You and your email to me with respect to catalytic converters and anti-theft shields being placed on those catalytic converters. So thank you very much for raising that question, because I was able to share it with the audience earlier today at the advisory group meeting.
Thank you.
Other comments from the attendees?
Yes, we have another request for comment. Individual identified as Jerry. Jerry, I'll be unmuting your microphone now. One moment. There we go. WebEx hiccuped on me. So Jerry, you are unmuted.
Okay.
I'm not hearing anything.
Thank you. Can you hear me?
About every fifth word, I think.
This is the moderator. Jerry, if you're having audio issues, what you can do is you can switch your audio over to your phone by selecting audio and video up at the top of your WebEx screen. Select switch audio and then follow the call-in prompts to switch over to your phone. And this is the moderator while we wait for Jerry's audio connection. It looks like there are no further requests from the other attendees.
Okay. I can go back to the advisory group until such time as Jerry is able to connect with us. I think it's Jerry Froelich, if I'm not mistaken. I see his name.
Oh, Jerry.
Yeah.
Yeah.
We know Jerry.
Yeah.
Let's pass on Jerry.
Yeah.
Is he there? Okay.
I'm not able to get it on. Can you hear me?
Yeah. I hear you.
Now we're
You're
here.
clear now.
Yep.
Okay. I'm sorry. Thank you, Matt. Thank you, Pat. The only points I agree with a lot of the comments that have already been here today. I wanted to bring up a couple little points as far as examples. One on the invoice example, like Pat, or I should say Jack was talking about earlier, would be the fact of what's charged out. So you get what I'm getting at is a clear example. What's charged out is 3 solenoids, but in the description of the repair, it says that it's false, and it says that they installed 4 solenoids. The parts are charged out correctly, but we have an inaccurate statement as far as what's going on. I also run into another situation on an invoice, the final invoice, where it will show a signature block in the acknowledgement notice for an oral increase. And this is a cashier that's had a customer sign it, and there was no increase. These all, in essence, are considered false and misleading, but the concern that a lot of people have expressed is the fact it's inaccurate. So will this end up resulting in a $100 fine, or one that would be not citable? So some of the concerns that some of the people have is if that's citable or not, that type of an issue. That's one question. I have 2 other points. You able to still hear me, Matt?
Yeah, I can hear you. I just don't know if I was supposed to answer or wait for the two other points.
Okay, well, I didn't that one, so I don't confuse you. Let's put it that way. For myself.
I would tell you that if the original presentation we did back in October related to the generation of an untrue or a false or misleading record or invoice had to do with a scenario where parts and labor were charged for that were not performed, not about the fact that they have the wrong ARD number on or that their invoice has the wrong address. It had to do with scenarios where it's a serious violation of the Automotive Repair Act, but that we didn't prove intent that we would move forward with a disciplinary action. So in your scenario about the cashier having them sign off on the oral acknowledgement of additional authorization, which all, I mean, dealerships are the biggest ones with that one because they have, anyway, the point I'm making is that that is not in the realm of what we had envisioned related to issuing a citation. But, and I also would say, the thing about the solenoids, like it actually says 4 were charged out, but if the price was 3 and there was only 3 installed, and I don't even know if we're talking about issuing a citation in that situation either. More like.
That's what I'm getting at. That's some of the concerns that some people have. So
we're talking about something where it's actually like a problem, like we found a problem, but we can't improve intent, and that's where we would want to issue a citation.
Okay, and then one of the comments earlier was dealing with advertising and getting from other situations, from other companies. I do know for a fact with some of the dealers that I work with, they have manufacturer advertising that they have to put on that are not California compliant. Those are situations that you could come up into question as far as a cite and fine, or if it is just they need to be noticed on a inspection report. That's another concern that's been expressed also.
But not in compliant in what way though?
Say it's for air conditioning, and they aren't saying anything about installing any Freon on the air conditioning inspection. You can also look at where they say they're doing an oil change, and it doesn't describe if that oil is synthetic or how many quarts is in, if that's a synthetic oil in that price, and how many quarts are being installed in that price. And I've seen some manufacturers that have actually, it's a manufacturer ad that the dealership has to use because they are that manufacturer. They represent that manufacturer. And that's the type of thing that they have concern with on some of the cite and fine issue, if this is going to come up, because I brought it to their attention, but they still believe that, you know, they're at a between a rock and a hard spot. The spot is there in between the bar, and they're also in between the manufacturer that supplies them their vehicles and parts, etc.
I understand.
So it's more that I'm just wanting to throw out some issues so that you understand some of the stuff that's been talked about. Now, on failure to produce records, and this kind of goes with it, kind of isn't, but in 98, 84, 11, 3353, it does state that the records shall be open for reasonable inspection. And of late, I've been able to see some inspection reports where there's been requests for records. One in particular was the rep had requested records to be provided in 72 hours. The management of the company said that they couldn't, so the rep started writing them up for not providing records. Well, luckily the manager was prudent enough to write on the inspection report that the records they're asking for were with, after he had explained it already, were with an attorney, and he didn't know if he could get them back from the attorney in 72 hours. And then I have another inspection report that I saw, and this was for one complaint. It wasn't like what Jack was talking about, 60 days worth of records for all, cars that you worked on. These were dealing with complaints. Had another one that was dealing with the complaint, and they asked for the records that were needed. and they told them they'd be back in 7 days. So what some of the issues that have come out of that, and I was in admin court back in the days when I was with the Bureau, where we tried to, in the case, include failure to provide records. And at that time, the judge told us, well, you need to give them at least minimum 5 working days. What works best is for you to have an agreement and notate what the agreement is on the time. Even if you don't get an agreement, it may take more than once to go out there and request it. And all I'm getting at is a lot of the people were talking about different standards. Well, one office, 72 hours is a standard. Another office is 7 days as a standard. So that comes to the question is, well, I get them, if I don't get it to them within 72 hours, am I getting a $100 citation? When the law actually reads reasonable amount of time.
Okay, I understand. I take your point. And actually, I
And those are some of the
totally agree with you
concerns.
too.
Yeah, and that's why I'm rolling out some of the concerns. So,
Yeah.
everybody that's already commented have good legitimate comments. I'm just wanting to roll in another angle for some of the concerns on some of the stuff is all. Thank you.
Excellent comment, Jerry, and echoed by others prior to you, but I think that's a really good point for us to take into account. Honestly, I don't think we were envisioning number of days to respond to a records request by a Bureau field representative. I think it was more the example, correct me if I'm wrong, Matt, where I don't have records. What do you mean? The law says you have to have records. Maintain them for 3 years. And as Mr. Molodonov has advised the industry, keep them for 4 because of potential for civil litigation. So, it's more to the point of records aren't available or won't be provided at all, not the amount of time in which they're provided. I don't think we were envisioning any citations for that kind of missing a request for records.
And what you have to understand is this is what some of the industry pictures, quote unquote, the heavy hand of the Bureau, when in fact I worked with you for 27 years. It's not always heavy handed, but some people feel that way. And when they see things that aren't indicative of the situation, they start inputting and imagining more.
No, it just goes to the point of having to try and view it from each other's position. I mean, obviously I sit in this chair and say, oh, we would never do that, but you're in a different position now, having formerly worked with the Bureau, certainly can understand and are representing quite eloquently how someone in the industry might be concerned that it would be used in a heavy-handed approach. And that wasn't what I don't think any of our staff who worked on this proposal envisioned.
Well, that's what I try to portray to those individuals also.
Okay.
Thank you very much.
Yep.
Thank you, Jerry.
All right, we'll circle back to the advisory group members who still have hands came up again. So let me just make a point. We were scheduled to go to 3:30, or we have a parenthetical reference that says or until close of business. I think we are willing to go until as long as it takes to get the comments today. But I want to also say, if you failed to think of something and mention it, and you want to shoot us an email, we'll take comments even after we adjourn today. So, but in the meantime, we'll try to wrap up as many of these comments.
This is the moderator, just to quickly ask. We have a comment from Jonathan Summers about whether the presentation will be available for later viewing.
The PowerPoint presentation?
I believe so.
It's on the website. It's on the bar's website.
And I believe all of these are recorded and available on our website after the fact. Yes. All right, let me circle back to the Bar Advisory Group members. Johan Gallo.
Thank you, Pat. Just a quick comment. This is so important what we're working on right now. Just like when we went through disciplinary guidelines and everything else, I would strongly suggest that we continue a series of workshops to work through this so that we get it right. I mean, we're talking people's livelihoods, we're talking dollar amounts, and I realize it's important to get this thing moving forward, just like disciplinary guidelines and everything else. But with everything that's at stake and trying to define these things to make sure that we get it right, I would strongly suggest, and I know we're hoping that in July we get back together in person, but in the event that we can't, I would suggest that BAR continue to schedule a series of workshops that aren't necessarily tied to the advisory meetings, but so that we can continue to get this thing moving, but that we get it right. That's my only comment.
That's a good comment. I'm sure that this will not be the last workshop on this topic by any means. And it certainly makes sense given the possibility of the legislation that's tied to this, AB 471, which we've mentioned repeatedly throughout this workshop, that will have some amendments to these regulations if that legislation goes through this year. But yeah, and the reason we tie them to the advisory group meetings, I mean, not that we have to, but everybody's time is so valuable. You're involved in so many other things that we just try to make it easy to block a day, but we can do them on another day as well. Those are just the most convenient, it seems, for all parties.
Thank you.
Yeah. Nikki Ayers, Independent Automotive Professionals Association.
Hi, Pat.
Hi.
I'd like to go back to the beginning of this whole thing, and Matt mentioned that there was a committee or a board that worked on this.
It was an internal work group, but yes.
Okay. Is it strictly a bar group, or was it outside of the bar? And what was the initial purpose of this group, and why did you come up with this particular program?
It was just bar people, and I'm trying to remember back. I had it in that other presentation that I did in October, but it was actually trying to determine if it would be worth doing worth actually creating a citation program related to automotive repair dealers or not. I generated some data that related to certain code sections over a 3-year period that showed that there might be some abuse as far as at the industry level, as far as we weren't effectively dealing with certain violations. And so it was an option. We were trying to come up with different options to, it was trying to come up with additional enforcement options or enforcement tools to be more effective, basically, put it that way.
And that was the sole purpose of the group to start with.
It was to look at additional enforcement options for bar, yes. But I'd have to go back to my PowerPoint presentation from October. I'm sure I was a lot more eloquent then.
Okay, I don't remember. Sorry. Thank you.
And I think I've already pointed out that I, as well as Assemblymember Lowe and others, were being questioned by media with respect to what does the Bureau have in its resources to inform consumers about shops. There was talk at one point of creating a rating system of automotive repair shops to give consumers more information about the industry and in being able to make educated decisions about facilities they could take their vehicles to. We were looking at and felt, I guess, somewhat vulnerable in the fact that we had education on one end of the spectrum with office conferences or proactive conferences, and then formal disciplinary actions where you revoke someone's license and or possibly put them on probation due to some very serious violations of the Automotive Repair Act. But there was nothing in between in terms of our what did you call it? Additional tools?
Yeah, we needed additional tools.
So I think in response to that and to potentially address the potential for legislation, which we did see initially from Mr. Lowe last year, where he kind of attempted to look at the rating system, we thought we'd try to get ahead of the game and see if there might be a way to address some of these issues, knowing that it was coming potentially one way or the other through legislation or just others monitoring bars enforcement activities, namely the media.
Okay.
And a good question. Thank you for asking that again. Let's go to Christina Bowders with the Oil Change Association.
Hi, everybody. I am new, so this is my first time here, but I did have a question, and it might be really not relevant, or maybe you guys all know this, but the monies that are collected from the citations, where does that money go? Does it go back to the bar? Does it go to the state? And then furthermore, what is the money used for afterwards?
No, good question.
It goes back to the Bureau's Vehicle Inspection and Repair Fund. I assume would be just like a citation that's collected under the smog check program, or unlicensed activity usually doesn't come with a dollar amount. It's usually just an order of abatement. The cost of the citation, you're trying to get the facility registered, so that's a $200 to become registered each year. So that's the dollar amount, I guess, if you will, for the citation. So it usually comes with an order of abatement, unless after serious several attempts to try and get the facility registered, they're still ignoring you. You might go beyond an order of abatement and issue a dollar amount. But yeah, that's all deposited.
Would there be a
That's all deposited
would there
into
be a
our
possibility?
Yeah.
Okay. Would there be a possibility to earmark it towards educational programs to, put out the information for this program and to train facilities to better service consumers?
I like the idea. I don't know without legislation if that could be done by the Bureau. I believe not. I'm going to step out on a limb, and my instincts say that we would probably need some language in the statutes, and potentially in the bill that's pending that we've talked about several times, to maybe spell that out. I don't think the Bureau has the ability to carve out its funds that way. So, that's a good question, a really good idea too.
Thank you. That's all I have.
Thank you.
Let's go to Dave Kusa next with the Automotive Service Councils of California.
Thanks again, Pat. Matt, just wanted to say thanks. I'm guessing this was a little bumpier ride than you thought it would be, but thank you for the presentation.
In all fairness, it's exactly what I expected.
Okay, good. Don't work too easy on you. Sorry. my last comment and request would be that, the second to last, as we review these, as they're reviewed and changed and modified, that, put on the hat of somebody who is looking to cause trouble for repair shops, not necessarily helping repair shops in these things, right? How can these regulations be abused, and write them, modify them to eliminate that as much as possible. And then lastly, Pat, I just want to say thanks. Obviously, maybe it's not obviously, right? I mean, this advisory group, right, is not required anywhere. So, you certainly, the bar could certainly pass these regulations with no input from industry. So, as a shop owner, and speaking for other shop owners, I appreciate the opportunity to have that input, so that the regulations not only work for the Bureau and the consumers, but are fair to industry. So, thank you for keeping this group going, and I hope that it goes on for the foreseeable future.
Thank you. Happy to do it. I appreciate you pointing that out. It doesn't work for bar if it doesn't work for consumers and industry. We're all in this together. Thank you. Let's see. Any other comments? Any moderator or any others comments from the attendees that might have popped up?
I don't see any raised hands. If you'd like, I could open up the Q&A feature again.
No need to.
Okay.
I think people are pretty comfortable or familiar with the hands raised feature of this format by now. Okay, any last thoughts from any of the advisory group members? Okay, as I said, if you think of something after we close out today, send us an email. Send Matt, send me an email. We'll entertain comments even after we've closed today. I would like to hold another workshop in July after our next advisory group meeting. I don't think there would be a chance to get together any sooner than that. I won't put any undue pressure on Matt to commit to something like that. And the meeting, a meeting in July would be contingent on us having developed something in response to these comments that we've received today that would move the needle on some of these proposals to the point where we would be able to get some new feedback. If we're able to put together some revisions or changes based on these comments by the July, I'd like to have another workshop. Any objections to that?
All in favor.
Okay.
Thank you very much, Pat and Matt. Appreciate all your work on this. Believe me, we realize how much work goes into all these.
Yeah. Thank you so much. And Matt, great job. Thank you to the moderator and co-moderator. We have two. Thank you for all your help today in running such a smooth workshop, as well as the earlier bar advisory group meeting today. Great job, everyone. Thank you all for attending, and thank you for your comments. We look forward to continue working with you on this proposal. Have a good day. Have a good rest of the day, and have a good rest of the week.
Thanks again, Pat. Thank you, Matt. Thanks, everybody. You guys take care.
Bye.